Good morning. Today I'm going to give a brief update on a recent case involving the Personal Property Security Act, new legislation been in effect for 3 or 4 years, and of course subject to a Senate review, I think, coming up in January. There have been quite a few issues raised with the operation of the Act, and I think the simplicity of it, or whether or not the new terminology is confused, particularly small and medium enterprises. It seems to be working quite effectively for larger companies, but a lot of smaller organisations which can't afford expert legal advice have raised queries about it. A few teething problems and questions of law arising, of course, under the new legislation. And the case I'm going to comment on very briefly today is Re Arcabi, ARCABI Proprietary Limited. Receivers and managers appointed, ex parte Theobald and Herbert, who were the receivers and managers. And it's a decision of Master Sanderson over in the Supreme Court of Western Australia, 2014, WASC at 310. And it's an interesting decision because in it the Master considers whether or not the particular special definition of a lease or a bailment, which is provided for under the PPSA, is actually attracted on the facts of the case. And the facts were fairly straightforward. Receivers and managers appointed over an operation, Askaree, which used to take in, by way of bailment, coins and other valuables on consignment and also for storage. And in the classical case, under the old law, of course, if you were the Bay law and you handed over the property to the bailee, well, no title was passing. It was simply a possessory right of some sort. And at the end of the bailment, or upon giving notice, you could get the property back. Question whether or not in this particular case the extended definitions pursuant to section 12 of the PPSA in terms of bailments and leases operated to extend the operation of the Act to the coins and other material which was being left, with the result that if there was no registration, then the financier holding under a general security facility would be able to claim priority. This, of course, is the big danger of the PPSA, that you may have created a possessory interest in a particular chattel. You've given it to somebody. The appearance of possession creates the notion that you've actually got some interest in it, and therefore a credit provider might decide to extend you credit on the basis of your apparent possession. PPSA operates there by creating various special forms of lease and bailment as defined, which effectively override the old law with respect to title if the bailment has continued for a particular period of time. And in this particular case, that was the question, because the secured financier, or rather the receivers, were simply asking whether or not they were entitled to return the property to the initial Bay laws, or whether or not they had to sell the property, I suppose, and give the proceeds to the security provider. And the judgment's an interesting one. I'll just summarise it briefly. Master Sanderson at paragraph 18 notes that a bailment, of course, is where a Bay law delivers the goods to the bailee upon promise express or implied. They'll be delivered to the Bay law or dealt with in a stipulated way. It's the old High Court case in Hobbs and Petersham Transport. And the question here, as he says, is whether the arrangements were of such a nature as to be captured by the security interest provisions of the PPSA, which affects bailments. And paragraph 19, he tells us that 2 types of bailment may comprise a security interest under the PPSA. First, there may be an in-substance security interest under section 12.1 of the PPSA, but only if the bailment secures payment or performance of an obligation. Alright, so there might be a bailment where it's actually securing the performance. And remember, the PPSA is looking all the time at the substance, not the form of the transaction. And secondly, as he notes, there might be a deemed PPS lease under section 13, and therefore a security interest under section 12.3c. And question as to whether or not it secures a payment obligation, and he notes at paragraph 20 that there are a number of indicia which you can derive from the older cases overseas which suggest that. Remember, a lot of our law in this area comes from Canada and New Zealand, which both had acts in effect before the new act was introduced. Alright, what are those indicia? Well, paragraph 20a tells us the bailment might provide ownership of the goods is going to vest in the bailee on expiry of the bailment. The bailee has an obligation to purchase the goods, or an option to purchase, or terms of the arrangement are for a major part of the economic life of the goods, and the minimum payments under the bailment amount to substantially all the capital cost of the goods. So what we're really talking about there, in a sense, is not exactly a financing lease, but a situation where you are effectively buying the property over a prolonged period of time and describing it as a bailment. And you describe it as a bailment with a view to, of course, keeping title and therefore preserving your interest. And in this position, the receivers took the view, which the master accepted, that this wasn't such an arrangement. No question about that. Then the question of whether they were PPS leases, and this is involved with someone sending goods on consignment for a time or a period. Bailors regularly engaged in the business of bailing goods, and the bailment is then deemed to be a PPS lease. And here the master decided also that, following some evidence from the receivers, that it wasn't a PPS lease. So, an interesting case, have a look at it. I'm dealing with it in much more detail in a long piece I'm putting on Askaree generally, a subscription service, where I'll be discussing all PPS provisions in some detail. And Arcabi is just a recent case which you need to note if you're working in the area.